taken into account by courts when sentencing offenders. The use of the epithets substantial and compelling cannot be interpreted as excluding, even from consideration, any of those factors. They are neither notionally nor linguistically appropriate to achieve that. What they are apt to convey is that the ultimate cumulative impact of those circumstances must be such as to justify a departure. It is axiomatic in the normal process of sentencing that while each of a number of mitigating factors, when viewed in isolation, may have little persuasive force, their combined impact may be considerable. Parliament cannot have been ignorant of that. There is no indication in the language it has employed that it intended the inquiry into the possible existence of substantial and compelling circumstances justifying a departure to proceed in a radically different way, namely by eliminating at the very threshold of the inquiry one or more factors traditionally and rightly taken into consideration when assessing sentence. None of those factors have been singled out either expressly or impliedly for exclusion from consideration. Close quote. In State versus Malchas, Supra, State versus Dodo, 2001, Volume 1, SACR 594, it's a Constitutional Court decision, and State versus Vilakazi, 2009, Volume 1, SACR 552, a Supreme Court of Appeal decision, regarding the imposition of an appropriate and proportional sentence in the context of the prescribed minimum sentence of life imprisonment and the determination for when the prescribed sentence may be departed from. The following extract from Vilakazi, paragraph 3, is apposite, and I quote, "The Constitutional Court reminded us in State versus Dodo that punishment must always be proportionate to the deserts of the particular offender, no less but also no more. For all human beings ought to be treated as ends in themselves, never merely as means to an end." Close quote. Form SAP 69 confirmed that accused has no previous convictions.
The form SAP 69 is one
When the matter came before this court on 25 November 2015, Mr. Matopo, on behalf of the accused, duly informed this court that he was unable to proceed with mitigation of sentence as he was unable to secure a social worker's report. Ms. Leroux informed the court that she had no objection to proceed with the leading of the state evidence in aggravation of sentence. After having carefully considered the matter and taking into consideration the unnecessary delay that a postponement may have caused in the finalization of this matter, the court ruled that the state proceed with the leading of evidence in aggravation of sentence. I will accordingly hereunder proceed to appraise the evidence on sentence in the chronological order that it was presented. The state called the evidence of the following two witnesses in aggravation of sentence. Professor Rachel Catherine Jukes, hereinafter referred to as Jukes, who testified inter alia as follows. That she is the Director, Gender and Health Research Unit, Medical Research Council, and an Honorary Professor, School of Public Health, University of the Witwatersrand, Johannesburg. Jukes confirmed that she has undertaken numerous projects and research on abuse in respect of women since 1995. She confirmed the contents of a 39-page curriculum vitae, which undoubtedly classified her as an expert in her field, and more especially to authoritatively make submissions to this court regarding intimate partner violence and killing in South Africa. Her curriculum vitae was admitted onto the record of proceedings as Exhibit Y. Jukes submitted that the killing of women by male intimate partners is the most extreme form of intimate partner violence, as well as the most extreme consequence of intimate partner violence. She raised a concern that figures that were obtained from Tshwane schools in 2014, whilst not from a household survey, did not suggest that partner violence is on the decline. She regarded this phenomenon as extremely concerning, having due regard to the fact that government has identified violence against women as a national scourge, and over the last 2 decades has been working for its eradication. For example, through the Domestic Violence Act 116 of 1998, the government's 365 days of activism policy, and the 2011 launch of the National Council on Gender-Based Violence. A survey conducted in 2009 revealed that 57% of women who were killed, where the perpetrator was known, were killed by intimate partners. In addition, she submitted that South Africa's female homicide rate was 6 times higher than the global rate, and further that this was double than that found in the United States of America. A research conducted in 2013 by the Medical Research Council into the prevalence of intimate femicide globally revealed that from a data set of 66 countries globally, 39% of homicides of women were committed by an intimate partner. The study further found that women were 6 times more likely to die at the hands of a male intimate partner than men were to die at the hands of a female intimate partner. That the 2009 research revealed that intimate femicide is much more common in South Africa than in most other countries of the world, and the proportion of intimate homicides in South Africa is much higher than the global average, which is 57% versus the global average of 39%. Duke stated that in terms of the 2009 survey, intimate femicide is much more common among younger women and among colored and African women than older or white and Indian women. She submitted that very often there is a known history of previous intimate partner violence. She testified that it was very common for women victims of intimate femicide to have consumed alcohol. She confirmed that the blood alcohol level of the deceased, being 0.06 gram per 100 milliliters, was only slightly above the driving limit, showing that she was not heavily intoxicated when she was killed. Jukes profiled the age group for men who kill their intimate partners as being between 30 to 44 years of age. She referred to the research work conducted by Shanaz Matthews, hereinafter referred to as Matthews, and testified that during the interviews of her subjects, Matthews found that they described having experienced extreme harshness and cruelty in their childhoods at the hands of their parents, mostly their mothers or other caregivers. Mothers who were not cruel were often emotionally unavailable due to their own difficulties such as depression or alcoholism. Fathers were notably absent from their lives. All this resulted in the offenders growing up feeling unloved, insecure, and powerless. I pause to mention that the aforementioned criteria does not apply to the accused, as per his testimony and that of the social worker. Matthew's research also revealed that some of the men had characteristics which are commonly associated with borderline personality or narcissistic personality disorder, including low self-esteem, lack of guilt, lack of empathy, lying, or poor impulse control, with a tendency to react with extreme rage and aggression to perceived threats to self-esteem. Research chiefly conducted among black African men shows that South African men have strong expectations that they should be in control of their partner, respected by her, and that the use of violence within limits is a legitimate part of that control. It is noteworthy to mention that the accused admitted to slapping the deceased on occasion to keep her on track. Jukes stated that an area which is noted to particularly cause conflict is jealousy and practices related to having multiple partners. It is absolutely normative for South African men to have more than one sexual partner, especially younger men. She submitted further that it is particularly common for men to continue intermittently to have sex with the mothers of their children after they split up. Matthew's research had revealed that almost all her study participants had been repeatedly violent to their partner before she was killed. Often, the violence was from jealousy or to defend honor. For many, violence was entwined with substance abuse. I pause to mention that the evidence led during the trial is demonstrative of the accused being repeatedly violent to the deceased before she was killed. Most of the subjects interviewed described the act of killing their partner as one of snapping or losing control, but it was often an act which was committed to regain control. Most men felt belittled and humiliated at the point when they killed their partner and felt no remorse. At this point, they saw her as being of such little value that she deserved to be the victim of his outburst of extreme aggression. The killing was a final attempt to regain the upper hand over their partner, one who was no longer regarded as worth having. Dukes testified that in many jurisdictions, intimate partner femicide is viewed as a heinous crime and carries a heavy prison sentence. She testified that during 2012, the range for sentences in the Houston-Harris County, Texas, was between 20 to 50 years, with an average of 34.9 years. She drew a correlation with South Africa and pointed out that we characteristically have much shorter sentences for intimate femicide. In 2009, the Medical Research Council dataset showed that the average sentence for convicted perpetrators of intimate femicide was 12.5 years, with a range from 3 to 40 years. That 3 to 40 years. She submitted further that a simple ecological analysis would suggest that the much lower prevalence of intimate femicide in the US may be related to the long sentences that are given in such cases. In South Africa, it is easy to assume that our difficulty in reducing the problem of intimate partner violence, intimate partner femicide, may be part due to the short sentences that many perpetrators receive. Alternatively, the short sentences may reflect the generally socially permissive attitude towards partner femicide. Jukes unequivocally concluded from the documents that were presented to her, as well as the factual findings of this court in convicting the accused, that this case was a locus classicus of intimate partner violence, and that the court take this fact into consideration when imposing a suitable sentence upon the accused. That, in essence, concluded the evidence of Jukes. Mrs. Dikeledi Elizabeth Marawa, hereinafter referred to as Marawa, the biological mother of the deceased, who deposed to a victim impact statement on 24 August 2015, further testified inter alia as follows. I pause to mention that a victim impact statement is defined as, and I quote, a sworn statement by the victim or someone authorized by the victim to make a statement on behalf of the victim which reflects the physical, psychological, social, financial, or any other consequences of the offense for the victim, presently and in the future, close quote. Marawa testified that the death of the deceased has affected her emotionally and that she has spent sleepless nights for a period of almost 5 to 6 months. She suffered with loss of appetite and memory. Further, that the death of her child affected her mentally and emotionally, which resulted in her having nightmares. She was rather aggrieved at the manner in which the deceased was portrayed by the accused. She was rather upset about the defamatory statements that were made regarding the deceased, as well as the negative allegations in respect of her character. Marawa confirmed that she was attending counseling sessions on a monthly basis. The untimely death of the deceased has severely affected her health in that she experiences severe headaches, suffers from emotional stress, nervousness, and has suffered drastic weight loss. Her deteriorating health has caused her to consult various medical practitioners on many occasions. She stated that the deceased was the sole breadwinner who provided for her and the deceased mentally disabled brother. In addition, the deceased was also supporting her unemployed brother's children. The death of the deceased has severely affected her financially, as she has no other means of financial support. Marawa testified that the deceased was a God-fearing and kind person, a member of the Mothers' Union who also had a greater community at heart. She testified further that the deceased was studying towards a degree in psychology at the University of Witwatersrand and to have graduated in September 2014. Marawa submitted that as a result of the death of the deceased's daughter has been removed from her home by the estranged husband, who has prevented her from seeing the child. This state of affairs has caused her tremendous amounts of stress and heartache. It was put to this witness during a cross-examination that the accused apologized for the pain and embarrassment caused to her family, and further that he sympathized with her for the loss suffered. Marawa was adamant that if it were the intention of the accused to have apologized, he would and should have done so previously. That in essence concluded the evidence of this witness. It has just been brought to my attention that there seems to be a problem with the mechanical recording device, and the technician is attending to it. Would it require the court to adjourn, or would you be able to repair it? The court is going to take a short adjournment in order for the mechanical recording device to be repaired, and will continue as soon as it has been repaired. Mr. Sebolai, the court's going to take a short adjournment for the recording device to be repaired. Good. Court will adjourn. In the matter of State versus Pusumuzi Donald Sebolai, the court having been informed that the recording device is now repaired, the court will continue with its judgment. The bereavement counseling report completed by educational psychologist Dr. C.D. Sekukune, hereinafter referred to as Sekukune, in respect of the deceased's daughter, was handed in by consent as Exhibit BB. This fact obviated the need for this witness to testify. The report, inter alia, set out the following information for the due consideration of this court. Sekukune confirmed that the child was born on 17th May 2007 and was 7 years and 1 month old when she first consulted with her. She had 3 counseling sessions with the child. It was reported to her that the child was devastated by her mother's death. She missed her mother tremendously and had exhibited a sense of sadness and loss. A visit by this witness to the school revealed that the child seemed to be okay, but had become rather quiet. The educator further confirmed that the child experienced fluctuating emotions. Sekukune concluded that the child required ongoing psychological, social, and academic support. She further submitted that the child would have to deal with the loss of her mother for her entire life. She was of the view that the child required constant support, empowerment, and monitoring to protect her from her peers and community in order to minimize the distractions that could be a hindrance to her normal development, for example, depression and self-concept. This, in essence, concluded the report of this witness, and the state indicated that it had no further witnesses to call. The defense called the following 3 witnesses in mitigation of sentence. Mrs. Elizabeth Selekani Sebolai, hereinafter referred to as Sebolai, the mother of the accused, testified inter alia as follows. Sebolai confirmed that the accused did not experience any traumatic childhood experiences and did not exhibit any problems whilst growing up. She further testified that he was not a violent person whilst he was being raised. She confirmed that it was only the accused and herself that were employed in the household. The rest of the immediate family relied upon their income for support. She stated that the accused would supply groceries on a monthly basis, and further that he would inquire if they were running short of any items of food. Sebolai confirmed that the accused had been involved in community work whilst at Josie FM, that his gospel program on a Thursday was very popular with his listeners, and this fact contributed to his fame. In addition, he assisted members of the community with food and other arrangements. She confirmed that the accused had 3 minor children whom he supported. She testified that she suffered with severe shock, stress, and depression as a result of being informed of the incident relating to the death of the deceased. This caused her to be admitted to hospital for a period of time. She is still suffering with ill health and receiving medical treatment. That, in essence, concluded the evidence of this witness. Mr. Vusumuzi Donald Sebolai, hereinafter referred to as the accused, testified inter alia as follows. The accused confirmed that he enjoyed a fairly good and stable upbringing within his family unit. He confirmed that he had 3 children from 3 different mothers, and that prior to his arrest, he supported his children both financially and emotionally. The accused confirmed the testimony of his mother regarding the fact that he financially contributed to the upkeep of his immediate family of 10. He testified that his father is a pensioner and ultimately his responsibility. In addition, he confirmed that he was involved in community projects and was concerned with the well-being of the members of his community. The accused admitted that he had slapped women. However, he was of the view that this was not tantamount to assault, but rather a reprimand. The accused testified that he felt very bad and that it was the first time for him to experience such pain. As regards the question of remorse or regret, the accused testified that he wished he could, and I quote, reverse everything, close quote. He stated that he realizes that the deceased was the sole breadwinner in her family and offered to help the family financially. He was of the view that he would be in a position to obtain employment upon his release from prison. He testified that his chances of employment were fairly good, provided he was not incarcerated. During cross-examination, the accused maintained his innocence and submitted that the deceased was stabbed whilst they were fighting for the knife. The accused maintained that the deceased had stabbed herself. He further testified that it was his intention to subsequently take her to hospital for treatment. Hence, after cleanup operations in the flat, he placed the knife and the deceased's bloody clothing in a motor vehicle, arguing that these would have been shown to the hospital staff when he took her for treatment. He conceded that Dr. Morele was correct when he testified that the deceased would have been saved had she received prompt medical treatment at the hospital, which was a mere 900 meters away. That in essence concluded the evidence of the accused. Ms. Siphumelele Mbata, hereinafter referred to as Mbata, the social worker tasked with the compilation of the pre-sentence report, Exhibit CC, testified inter alia as follows. Mbata testified that the accused was born on 23 July 1977 as the third of 4 children. He was raised by both parents in a stable environment wherein good morals and values were instilled in the accused. The accused confirmed to Mbata that he was not exposed to any form of abuse which could have contributed to the committal of the offense. The accused confirmed that he was supporting his deceased sister's 3 children, aged 11, 8, and 1 year old. The accused confirmed that his mother was the sole breadwinner in the household with additional assistance from the accused. Mbata confirmed that the accused fathered 3 children from 3 different mothers, and these children were 10, 4, and 2 years old. She confirmed having been advised by the accused that all 3 of the mothers are currently employed and able to cater for their children's basic needs. The accused enjoys a good relationship with his erstwhile partners. She testified that despite the acknowledgement of violence on the part of the accused, he had never been abusive nor violent towards his partners. The accused was the only child in the family that completed grade 12 and followed up with a course in information technology. Financial difficulties within the family caused the accused to stop his studies after 2 years. The accused subsequently obtained employment as a radio presenter at Josie FM. Mbata confirmed having been advised by the accused that he enjoyed good health, which was further confirmed by a recent medical examination in prison. The accused confirmed to Mbata that despite the fact that he consumed alcohol on the evening of the incident, his judgment was not impaired. Mbata confirmed having been advised by Palesa Motladi, hereinafter referred to as Motladi, a mutual friend of the accused and deceased, that the relationship between the aforementioned was characterized by abuse. She described the accused as a violent person who sometimes assaulted the deceased. In addition, she cited the incident when she had observed the deceased with a bloodied nose caused as a result of the accused's actions. Motladi described the deceased as a loving and caring person. She confirmed that the deceased did not exhibit any behavioral problems on the occasion that she consumed alcohol. I pause to mention that this is contrary to what the accused would like this court to believe. Mbata confirmed being told by the accused that he maintained his innocence despite the conviction and the factual findings of this court. She stated that the accused was adamant that the deceased was accidentally injured whilst he was trying to retrieve the knife from the deceased during an altercation. The accused informed her that he was remorseful for the death of the deceased. Further, that he was not in his right state of mind after the incident and had acted out of shock and fear when he failed to call for help. The accused confirmed that the deceased was a breadwinner for her child and family and verbalized a desire to financially support the deceased's family should he be given a non-custodial sentence. The accused stated to Mbata that he is emotionally and psychologically affected as a result of the incident. The accused informed this witness that the deceased presented with negative behavior once she had consumed alcohol, in that she would become jealous, possessive, and would demand his phone in order to examine the calls. The accused informed her that this is what led to the incident. The accused testified in his defense that the cause of the argument was as a result of him instructing the deceased to leave his premises for a period of time due to the fact that he wanted his child to stay with him. This version is diametrically opposed to the aforementioned statement made by the accused Tumbata. Mbata also dealt with the victim impact statement of Marawa and the bereavement report in respect of the deceased child. This aspect has already been dealt with, and as such is unnecessary to duplicate the evidence in respect of the aforementioned. Mbata testified that the offense committed is unjustifiable and the courts have a duty to sentence perpetrators accordingly so as to send a strong message to potential offenders that such behavior cannot and would not be tolerated. Mbata testified that the accused has stressed the fact that he did not intentionally kill the deceased, and further has failed to acknowledge that he also contributed to the death of the deceased by not seeking assistance immediately when he realized that the deceased had been injured. She recommended that the accused be dealt with in terms of the provisions of Section 276, subsection 1, subparagraph B of the Criminal Procedure Act 51 of 1977. That in essence concluded the evidence of this witness and the case for the accused in mitigation of sentence. Mr. Matopo, in mitigation of sentence, argued inter alia as follows. He reiterated the personal circumstances of the accused and the evidence that was led in mitigation of sentence as dealt with herein above. Matopo argued that this court must consider the totality of the evidence when determining a suitable sentence that is to be imposed upon the accused. He argued further that the court take into account the degree of violence involved and that this court must be mindful of the fact that the deceased only suffered one stab wound. He argued further that the accused still stood by his version in that there was a struggle, despite the testimony and finding of Dr. Marule that he did not see any injuries commensurate with a struggle between the parties. He argued that the court take into account that the accused does not have a degree of violence in his innate nature, further, that the killing of the deceased was not violent or brutal in any manner whatsoever. Insofar as substantial and compelling circumstances were concerned, the following was placed before this court for due consideration. That the accused has no previous convictions. The personal circumstances of the accused, as testified to by the witnesses and the reporter from Bata. Further, that the accused supported a family of 10, both financially and emotionally. That there was no degree of violence or strong violence on the part of the accused. That the accused was a suitable candidate to be rehabilitated in a shorter space of time. That the accused was not a danger to society. That the accused has been and still is regretful of the death of the deceased. It was further argued that the accused has not changed his version of the events that occurred at the death of the deceased, and this fact should not be viewed as a lack of remorse on the part of the accused.
anga kako e na e wa ko ha mo pasolo ko ya kantila e lo ko he mo pasabelo o kayo dano liso he asero ko liso mo la kadwa ele wai tola ka selo mo sinira he.
That all the mitigating factors cumulatively amount to substantial and compelling circumstances. The court should take into account that the mother of the accused was meant to have retired in 2014, but due to the accused's incarceration, she has to continue working so as to support the family. That, in essence, concluded the submissions regarding the substantial and compelling circumstances that the court take into account so as to enable it to deviate from the imposition of the prescribed minimum sentence. In addition, Matopo submitted that an appropriate sentence to be imposed would be a term of imprisonment between 10 to 12 years. Mr. Matopo was requested to address this court and furnish reasons as to why it should not impose a sentence higher than the prescribed minimum sentence. He submitted that the court take the following facts into consideration. That the crime was not so brutal, that the court should not teach the accused a harsh lesson as he was a first offender, that in essence concluded the submissions in respect of mitigation of sentence. Ms. Leroux, in aggravation of sentence, submitted inter alia the following be considered as aggravating factors. That in terms of the victim impact statement, it is clear that the suffering of the deceased mother was threefold, namely, mentally, financially, and physically. She stated that the suffering experienced by Marawa was severe. That as per Sekukune's report, the deceased's daughter will have to endure the effect of the death for a very long time and will have to deal with such a loss for the rest of her life. That due to the senseless act by the accused, the child would have to grow up without the love, nurturing, and guidance of her mother. That incidences of domestic violence over the last 2 decades shows no signs of decreasing. Domestic violence has been identified by government as a national scourge, resulting in legislation and national projects to educate and create awareness. That the 2009 study, as testified to by Jukes, clearly indicated that 57% of all women were killed in South Africa were killed by their intimate partner, as compared to the international figure of 39%. She argued that this court duly take into account the pattern of violence displayed by the accused, which not only emerged during the state's case, but even from the testimony of Professor Cooper. The accused had admitted to being violent in 2 previous relationships and saw nothing untoward in effecting physical reprimand upon his partner. That the picture painted by the state witnesses of the accused is that of an abusive man with a short temper who hated women. That the accused showed absolutely no insight into the crimes that he committed, and that he failed to accept responsibility for the murder of the deceased. that the alleged remorse verbalized by the accused during the pre-sentencing proceedings is not tantamount to genuine remorse. She argued that the evidence presented by the state is sufficient to safely conclude that the accused has a propensity of violence. That the accused fits the profile of an abuser, having due regard to the evidence of Professors Cooper and Jukes. The accused carried a mask to show kindness and rejected violence against women. However, in court, he was a totally different person. He humiliated the deceased over a short duration of their relationship. Further, that the accused blamed the deceased for all the strife in the relationship and for his current plight. That the accused stabbed the deceased in cold blood and continued thereafter to foster his own interests. Ms. Leroux submitted the following be considered as mitigating factors. The evidence tendered indicated that the accused was the main breadwinner for his 3 children and extended family, as well as the fact that he has no previous convictions. Leroux argued that the personal circumstances of the accused were not weighty enough so as to justify a deviation in the imposition of the prescribed minimum sentence when weighed against the interests of society, and particularly having regard to the brutality involved and the heartless fashion in which the offense was committed. Further, that there were no substantial and compelling circumstances to cause a deviation in the imposition of sentence. Leroux argued that the sentence imposed be greater than the prescribed minimum sentence. That in essence concluded the submissions by the state in aggravation of sentence. It is noteworthy to mention that this court is duly enjoined to look at the aggravating and mitigating circumstances, and once these are carefully considered, to determine as to whether there are substantial and compelling circumstances that will cause it to deviate from the imposition of the prescribed minimum sentence of 15 years. The court will bear in mind that there is no onus placed on the accused to prove the presence of substantial and compelling circumstances, or on the state to prove the absence of such substantial and compelling circumstances. However, there rests a clear duty on an accused to produce evidence to convince the court that circumstances exist which justify the imposition of a lesser sentence. It stands to reason that such substantial and compelling circumstances may also be inferred to be present in the state's case or in evidence presented by state witnesses or by the prosecution itself. If no factual basis is laid for a finding that substantial and compelling circumstances exist which justify the imposition of a lesser sentence than the prescribed sentence, it follows that a court will be obliged under the statutory provisions to impose the prescribed sentence. This court is also aware of the various authorities where it was settled that substantial and compelling circumstances should not be found based on flimsy reasons, and in that regard I refer to State versus Malchas Supra. I duly take into account the evidence that has been led in mitigation of sentence, both viva voce and documentary, in determining the presence or absence of substantial and compelling circumstances. In addition, I specifically take into account the fact that the accused is a 38-year-old male with 3 minor children whom he used to support both emotionally and financially. In addition, he used to support his immediate family comprising of 10 members. He is a first offender. The accused was a useful member of society and well respected in the community in respect of his outreach program and assistance to the community as a radio DJ. The incarceration of the accused has negatively impacted upon his immediate family with serious financial consequences. I duly take into account the evidence that has been led in aggravation of sentence, both viva voce and documentary, in determining the presence or absence of substantial and compelling circumstances. In addition, I specifically take into account the fact that the death of the deceased has caused severe emotional, psychological, and financial hardship upon the family of the deceased. The impact that the death of the deceased has had on her child. In addition, the fact that the child will have to grow up without the love, nurturing, and guidance of a biological mother. As per Sekukuna's report, the deceased's daughter will have to endure the effect of the death for a very long time and will have to deal with such loss for the rest of her life. From the evidence led, it is clear that it was a senseless killing of the deceased by the accused. I further take into account the fact that after having stabbed the deceased in her pelvic area, which severed her femoral artery, the accused continued to further his own interests, whilst the life of the deceased oozed out of her in the presence of the accused. I take into account that the accused failed to take the deceased for medical treatment in order to save her life after observing her bleeding profusely. This conduct, in addition to the fatal stab wound inflicted upon the deceased, is clearly indicative of the fact that the accused intended for the deceased to die. Nothing more, nothing less. I find the entire conduct of the accused on the fatal day and subsequent days leading to his arrest nothing short of aggravating. I duly take into account that the accused escaped from the scene like a coward in the deceased's car with the single intention to evade arrest and subsequently flee from the Republic of South Africa. I duly take note of the pattern of violence and abuse that the accused had inflicted upon the deceased over the short period of time that they were in the relationship. I take note of the fact that the deceased was the sole breadwinner and that she was to have graduated with a second degree in psychology from the University of Witwatersrand. I take into account the evidence presented by the state, which is sufficient to safely conclude that the accused has a propensity of violence. That the accused fits the profile of an abuser as per the evidence of Professors Cooper and Jukes. I have duly given cognizance of the principles that need to be applied when imposing a suitable punishment upon the accused. I have carefully looked at the aggravating as opposed to the mitigating factors and have taken all other circumstances and factors relevant to sentencing and measured it against the composite yardstick of substantial and compelling in order to properly determine whether the aforementioned cumulatively justify a departure from the standardized response that the legislature has ordained. After careful consideration of all the evidence before me, And taking into account all the aggravating and mitigating and other factors that I'm required to take into account, I am of the view that as far as the accused is concerned, no substantially compelling circumstances exist to cause this court to deviate in the imposition of a lesser sentence than the prescribed minimum sentence. It is trite that sentencing, yes. Mr. Pule, the accused stands up. Sorry? No, I'm not. Carry on sitting. You may be seated. It is trite that sentencing is generally a matter of discretion left in the hands of the court passing sentence. The discretion, however, may not be exercised arbitrarily but reasonably and judicially within the parameters of legislative prescription. Given the current levels of violence and serious crimes in this country, it seems proper that in sentencing, especially such crimes, the emphasis should be on retribution and deterrence. I refer to State versus Mhlakaza and another 1997, Volume 1, SACR 515, a Supreme Court of Appeal decision at page 519, paragraphs D to E. Retribution may even be decisive, and the authority for that is State versus Kwanyana and others, 1990, Volume 4, SA 735, Appellate Division decision case at 749 C to D. The requirements of society demand that a premeditated, callous murder should not be punished too leniently, lest the administration of justice be brought into disrepute. The punishment should not only reflect the shock and indignation of interested persons and of the community at large, and so serve as a just retribution for the crime, but should also deter others from similar conduct. The authority for that is State versus De Blasi, 1996, Volume 1, SACR, an Appellate Division decision case at page 10, paragraphs F to G. What appears from the aforementioned cases is that in our law, retribution and deterrence are proper purposes of punishment, and there must be accorded due weight in any sentence that is imposed. Each of the elements of punishment is not required to be accorded equal weight, but instead proper weight must be accorded to each according to the circumstances. Serious crimes will usually require that retribution and deterrence should come to the fore, and that rehabilitation of the offender will consequently play a relatively smaller role. See State versus Swart, 2004, Volume 2, SACR, page 370. It's a Supreme Court of Appeal decision. Moreover, as pointed out in State versus Malchas, where a court finds that it is not bound to impose a prescribed sentence, the sentence to be imposed in lieu of the prescribed sentence should be assessed, paying due regard to the benchmark which the legislature has provided. Accordingly, the need for a strong emphasis to deter violent crime in our society is an absolute necessity that should not be compromised or subjected to any further scrutiny. The state is therefore enjoined, and indeed compelled, to be resolute in protecting human life against violation by others who are found wayward. The level of violent crime in our society has reached dangerously alarming proportions. It is the duty of this court, inasmuch as it is the duty of the courts of the land elsewhere, to deal with violent crime firmly as far as the letter of the law can stretch. See State versus Mashau, 2016, JOL 34327, GJ. In the unreported case of Mudau versus S, Matopo AJA stated that, and I quote, "Domestic violence has become a scourge in our society and should not be treated lightly, but deplored and also severely punished. Hardly a day passes without a report in the media of a woman or child being beaten, raped, or even killed in this country. This is in some respect a negation of many of their fundamental rights, such as equality, human dignity, and bodily integrity." Close quote. This principle was well articulated also in State versus Chapman. The citation for State versus Chapman is 1997, Volume 3, SA 341, a Supreme Court of Appeal decision at 345 A to B. The citation for Mudau versus S is case number 547/2013, delivered on the 31st of March 2014 in the Supreme Court of Appeal, and also cited as 2014 Zeska 43 at paragraph 6. This principle was well articulated also in S versus Chapman, where the court emphasized that women ought to freely enjoy the peace and tranquility of their living environment without fear, apprehension, and insecurity which constantly diminishes the quality of their lives. I am therefore of the view that the imposition of the prescribed minimum or lesser than the prescribed minimum sentence would be inappropriate, having due regard to the facts of this case. I believe that a sentence higher than the prescribed minimum would be appropriate, having due regard to the nature of the offense and the circumstances of this particular case. The proper approach to be adopted by a sentencing court which contemplates to impose higher than the prescribed minimum sentence seems to me to be the one adumbrated by Willis J. in State versus Mbata at paragraph 20, where he stated the following. And the citation for State versus Mbata is 2009, Volume 2, SACR 623 KZP. And I quote, "On that approach, there is as much a necessity for the court in its judgment on sentence to identify on record the aggravating circumstances that take the case out of the ordinary, as there is for it in the converse situation to identify those substantial and compelling circumstances that warrant the imposition of a lesser sentence than the prescribed minimum. The trial judge should identify the circumstances that impel her or him to impose a sentence greater than the prescribed minimum and explain why they render the particular case one where a departure from the prescribed minimum sentence is justified. The factors that render the accused more morally blameworthy must be clearly articulated." Close quote. The salutary approach was also endorsed in State versus Marquez as well, which is 2011, Volume 1, SACR 263, a Supreme Court of Appeal decision. Accordingly, in my view, the following aggravating circumstances have been identified to take this case out of the ordinary and which impel me to impose a sentence higher than the prescribed minimum of 15 years imprisonment. The killing of the deceased is an intimate partner killing and femicide. The killing of women by male intimate partners is the most extreme form of intimate partner violence, as well as the most extreme consequence of intimate partner violence. Violence towards women and intimate partner killings in particular is endemic in South Africa. The seriousness of the crime, the callousness of the accused's conduct, the lack of genuine remorse on the part of the accused. The accused fits the profile of an abuser as per the evidence of Professors Cooper and Jukes. The evidence led during the trial clearly indicates that the accused has a propensity for violence upon women. Domestic violence has become a scourge in our society and should not be treated lightly. The level of violent crime in our society has reached dangerously alarming proportions, especially in respect of women and children. Government has identified violence against women as a national scourge. The pattern of violence and abuse that the accused had inflicted upon the deceased over a short period of time that they were in the relationship. It is clear from the evidence that it was a senseless killing of the deceased by the accused. I further take into account the fact that after having stabbed the deceased in the pelvic area which severed a femoral artery, the accused continued to further his own interests whilst the life of the deceased oozed out of her in the presence of the accused. The accused failed to take the deceased for medical treatment in order to save her life after observing her bleeding profusely. This conduct, in addition to the fatal stab wound inflicted upon the deceased, is clearly indicative of the fact that the accused, cold-bloodedly and callously intended for the deceased to die and watched her die before his eyes, nothing more nothing less. The impact that the death of the deceased has had on her child, in addition the fact that the child will have to grow up without the love, nurturing and guidance of a biological mother. As per Sekukune's report, the deceased daughter will have to endure the effect of the death for a very long time and will have to deal with such loss for the rest of her life. The untimely death of the deceased has caused severe emotional, psychological, and financial hardship upon the family of the deceased, as she was the sole breadwinner. The testimony by Dukes regarding the survey conducted in 2009, which revealed that 57% of women who were killed where the perpetrator was known were killed by intimate partners. In addition, she submitted that South Africa's female homicide rate was 6 times higher than the global rate, and further that this was double than that found in the United States of America. That the 2009 research revealed that intimate femicide is much more common in South Africa than in most other countries of the world, and the proportion of intimate homicides in South Africa is much higher than the global average, a comparative analysis of 57% as opposed to the global average of 39%. All crime has harsh effects on society. What distinguishes domestic violence is its hidden, repetitive character and its immeasurable ripple effects on our society and in particular on family life. It cuts across class, race, culture, and geography, and is all the more pernicious because it is so often concealed and so frequently goes unpunished. See State versus Sebolai, 2000, Volume 2, SA, page 425, a Constitutional Court decision at paragraph 11, and State versus Phillips, 2011, Zaska 192. It is to my mind quite inappropriate, as has been the unfortunate tendency in certain instances in the past, to regard certain killings as domestic murders and therefore automatically less morally reprehensible. I have just been informed that the accused wishes a short break. He just wishes to relieve himself. The court will just take a short adjournment and continue thereafter. The court will adjourn. Thank you. Mr. Sebolai, can we continue? Thank you. Yes. The court is just going to repeat the paragraph 47 of its judgment, just before the short adjournment was taken. This is a quotation from the case of State versus Quella, 2001, Volume 1, SACR 546, Natal decision at page 549. It is to my mind quite inappropriate, as has been the unfortunate tendency in certain instances in the past, to regard certain killings as domestic murders and therefore automatically less morally reprehensible. I am of the view that the aforementioned aggravating circumstances of the crime, the nature of the offense, and the conduct of the accused clearly renders this particular case one where a departure from the prescribed sentence is justified. In addition, I am clear in my mind that the aforementioned aggravating circumstances and factors render the accused more morally blameworthy. There is moreover a chasm between regret and remorse. Many accused persons might well regret their conduct, but that does not without more translate to genuine remorse. Remorse is a knowing pain of conscience for the plight of another. Thus, genuine contrition can only come from an appreciation and acknowledgement of the extent of one's error. Whether the offender is sincerely remorseful and not simply feeling sorry for himself or herself at having been caught is a factual question. It is to the surrounding actions of the accused, rather than what he says in court, that one should rather look. In order for the remorse to be a valid consideration, the penitence must be sincere, and the accused must take the court fully into his or her confidence. Until and unless that happens, the genuineness of the contrition alleged to exist cannot be determined. I refer to the case of State versus Machichi, which I've alluded to previously in my judgment. I am of the view that the accused has not taken this court fully into his confidence, and as such, the genuineness of the contrition alleged to exist cannot be determined. I am inclined to conclude that the accused is more regretful than remorseful. I have duly taken into account and given credence to the evidence that has been presented, having due regard to the triad as espoused in State versus Zinn, together with the impact on the victims when considering a suitable sentence to be imposed. I have carefully considered the mitigating and aggravating factors present in this case, whilst carefully weighing and balancing them against each other. I have taken all the factors that are necessary, and as I am required to do, in the determination of a suitable sentence to be imposed upon the accused. The interests of society clearly demand that the courts take a more serious view of intimate partner killings and domestic violence. Further, that a clear message be sent that it is not business as usual to like-minded offenders. The accused may rise. In the results, the accused is sentenced as follows. In respect of count number 1, the accused is sentenced to 20 years imprisonment. In respect of count number 3, to 5 years imprisonment. In terms of Section 280 of the Criminal Procedure Act 51 of 1977, it is ordered that the sentence on count 3 run concurrently with the sentence imposed on count 1. In terms of Section 299, capital A, of the Criminal Procedure Act, the immediate relative of the deceased, Mrs. Elizabeth Marawa, is accordingly informed that she has the right, subject to the directives issued by the Commissioner of Correctional Services under subsection 4, to make representations when placement of the prisoner on parole, on day parole, or under correctional supervision is considered, or to attend any relevant meeting of the parole board. Thank you, Mr. Sebolai. Do you understand the sentence that is imposed upon you? Mr. Leroux, anything?
As a court please, my lord. Thank you.
Mr. Pule? Thank you. The court then having no further order of business for the day, that's the judgment of the court. The court will take the adjournment. Thank you.
Because the 520 one is perfect. Yeah?
Grab your camera and just shoot some of the stuff outside.